in the Westminster Magistrates Court between Government of the United States of America, requesting state, and Julian Assange, defendant.
It is now possible to stand back and emphasize that both the prosecution and the extradition request are extraordinary, unprecedented, and politicized in a number of striking ways.
Firstly, Mr. Assange's extradition is not being sought for any of those ordinary extradition crimes, such as murder, drug trafficking, but for the extraordinary crime of espionage, universally recognized as a political offense. And extradition for political offenses is barred under Article 4.1 of the Anglo-US Treaty, the only legal foundation for the request under international law.
The actual request issued by the US fundamentally misrepresents the facts in order to bring this case within the bounds of an extradition crime.
Moreover, we submit that extradition is barred under Section 81B because it exposes Mr. Assange to the real risk of discrimination on grounds of both his political and his foreign nationality at every stage of the criminal justice process in the US. Section 9.
WikiLeaks publications exposed outrageous, even murderous wrongdoing, including war crimes, torture, and atrocities on civilians. All witnesses attested to the fact that they saw the revelations and publications as part of a political project to promote democratic accountability and expose how war was being waged in Afghanistan and Iraq, and that states were abusing their powers under a cloak of secrecy.
Julian Assange described US policy in relation to the International Criminal Court, ICC, as a case study in the use of diplomacy to undermine international institutions.
In the prelude to this prosecution, President Trump had repeatedly referred to the press as the opposition party and the enemy of the people. He denounced the news media as a whole as sick, dishonest, crazed, unpatriotic, unhinged, and totally corrupt, and attacked them as purveyors of fake news.
The chronology of the case itself, the reversal of the Obama administration's approach, the novel and unprecedented legal basis of the prosecution, and the misleading nature of the evidential case presented all together point to a politically motivated prosecution. And for all of these reasons, Mr. Assange invokes the protection of Section 81A.
Turning to Section 81B, the test is whether there is a real risk or a reasonable chance that Julian Assange will be prejudiced or discriminated against at his trial, at the sentencing stage, or in the manner of his subsequent imprisonment by reason of his political opinions and or his foreign status.
Contrary to the position in England and Wales, the U.S. offenses with which Mr. Assange has been charged contain nothing approaching a prosecutorial requirement to disprove necessity. No such defense is to be found within the statute, and the U.S. government does not suggest such a defense exists.
Even if the decision to prosecute now was presumed to be justified, then the long delay does nonetheless require some proper explanation. Absent explanation, the court is entitled to conclude that there was culpable delay in bringing the prosecution for these offences, which the US now say are very serious, when all the relevant factors were known at the latest by 2012.
Section 91 affords a protection from extradition, where extradition would be rendered unjust or oppressive by reason of physical or mental disorder.
In this context, Mr. Assange relies upon the evidence of expert psychiatrists and psychologists who deal with his history of clinical depression and trauma and the high risk of suicide if he is extradited to the US.
It further exposes him to the virtual certainty of conditions of imprisonment that are both inhuman and oppressive. Finally, This unprecedented prosecution constitutes a flagrant denial of his right to freedom of expression and poses a fundamental threat to the freedom of the press throughout the world.